In today's lesson, we will be talking about what a deed is and the 3 types of deeds that you need to know for the Illinois broker examination. So grab a notebook, grab something to write with, and let's get started. Welcome to this channel. I am Nonya, your real estate tutoress. I am a licensed broker in Illinois as well as a licensed instructor. On this channel, I bring you the best tips and tools to getting your real estate license in Illinois. I also answer any questions you may have about the process. If you're new here, welcome and do consider subscribing. A deed is a document that's used to transfer ownership from one person to the other. All right, we talked about that in a different video, and in that video I also talked about the things required to make a deed valid. I'll put a link to this at the end of this video so you can jump on and continue to that lesson. But in today's lesson, we'll be talking about the 3 main types of deeds that you need to remember for the Illinois broker examination. They are the general warranty deed, a special warranty deed, and a quitclaim deed. All right, so let's go into each one of them. Real quick before we talk about the 3 types, I just want to explain some terminology. The grantor is the giver of the deed and the grantee is the recipient. So I said the deed is the document that's used to transfer ownership of real property, real estate, from one person to the other. The person who owns it and is transferring is the grantor. So the grantor is giving the grantee the deed. The grantor is transferring ownership to the grantee. The general warranty deed is sometimes called the warranty deed. And what you need to remember for the exam is that this is the most common type. So if someone is buying residential real estate, this is most likely the type they're going to get. The other thing you need to remember is that this is the only deed that has 5 covenants. And you need to know the 5 covenants just in case they throw a question in there about them. All right, so let's talk about the 5 covenants. The first covenant is the covenant of seisin. Seisin also means possession. In this covenant, the grantor is saying to the grantee, promising the grantee that she owned the property and she had the right to transfer ownership to the grantee. Because she's making this promise, if anything happens in the future that challenges the grantee's rights, they can recover damages up to the purchase price. The second one is the covenant against encumbrances. In this covenant or promise, the grantor is telling the grantee that there are no encumbrances or liens on this property except the ones that we already talk about in the deed. So if we don't talk about it in the deed, then it doesn't exist. Now, if we don't have anything, then we won't talk about it. So if the covenant is breached, the grantee can recover whatever damages they incurred when they were taking the encumbrance or lien off of their property. The covenant of quiet enjoyment, that's the third covenant. In this type of covenant, the grantor is guaranteeing that there is no third party out there who can stake a claim on this property. And the grantor is saying, if anyone comes up, I will be liable for any damages. The fourth one is a covenant of further assurance. Here, the grantor is saying that if they need to clear any cloud in title or anything that pops up in the future, they will do whatever is needed to clear the title. For example, if they sold the property and their spouse didn't sign off their rights to the property, they will do a quitclaim deed, which we'll talk about shortly, and then get whatever issues off. And then the fifth and final one is a warranty forever. Here, the grantor is saying that they will compensate the grantee up to the purchase price for any loss that they may sustain against the title in the future. So as we've talked about all of these things, you can see how this really does protect the grantee. And a grantor, of course, will not give this deed to the grantee if they cannot back up these 5 promises. In Illinois, the granting clause for the general warranty deed is convey and warrant. The second type of warranty is your special warranty deed. Now, this provides 2 basic warranties. And these you need to remember for the exam. The first warranty is that the grantor received title. The grantor is saying, yes, I own this property, so I received title to this property. And the second is during the time, so this is for a specific period of time, during the time the grantor owned the property, they did not encumber it any further. What this means is the grantor is only protecting the grantee against things that happen when they own the property. They're not making any promises on things that were prior to them getting ownership of the property. You will see a special warranty deed used in, for example, foreclosed properties, because the lender got the property after they foreclosed on it. So they're saying, yes, we went through the right channels, we got title to the property, and since we've owned it up until now that we're selling it to you, we did not further encumber the property. But we cannot guarantee anything prior to when we owned it. Another place you will see this is if the property was gotten by the grantor in a tax sale. Right? So the grantor received it through a tax sale. They don't know what happened prior to them getting it, and now they're selling it to you, and they will give you a special warranty deed. The granting clause for the special warranty deed is that the grantor remisses, releases, alienates, and conveys. All right, so this is the longest one. The grantor remisses, releases, alienates, and conveys. The third type we'll talk about here is your quitclaim deed. Now, in the quitclaim deed, there is no protection for the grantee. The grantor is making no warranties, no covenants. They're not even implying ownership. So what happens with a quitclaim deed is the grantor is saying, whatever ownership interest I have, I'm passing on to you. If the grantor had good, clean title, that's what the grantee gets. Now, if the grantor had no title, that's also what the grantee gets. All right. Now, the quitclaim deed should not be looked over because it is used also to cure a defect or a cloud in title. Now, what do I mean by that? And please remember this. The quitclaim deed is used to cure a defect or a cloud in title. A cloud in title could be, for example, if I changed my name after I bought the property, and then now I'm trying to sell it to somebody else, and they're wondering, okay, Mary Jane bought it, now Joan is trying to sell it. All right, so then I would do a quitclaim deed from my old name to the new name. Another cloud in title that this could cure is if your name is misspelled, and then you do a quitclaim deed to yourself and correct the spelling of your name. All right, so to wrap it up, right, we've talked about the three main types, and there are others in your book, so do read those. But these are the three main ones that I want to cover for the actual broker examination, because these you most likely will get questions on. All right, so again, the general warranty deed, greatest protection for the grantee, greatest liability for the grantor. Has the 5 covenants. All right, so the general warranty deed has the 5 covenants, and remember what those covenants are and the granting clause. Special warranty deed, 2 basic warranties. The grantor received title. Secondly, for the time that they owned the property, they did not encumber it any further. And then know the granting clause as well. The third one, your quitclaim deed. No protection for the grantee. Whatever the grantor has is what's being transferred over. All right, so it's as good as any type of deed if the grantor had all the rights to the property. It's also used to cure a cloud or a defect in title. So those are the 3 main ones you need to remember for the examination. If you haven't already done so, please do like this video, subscribe to this channel, and hit the notification bell so you are notified when I release new videos. I will link the next video here. This is where you will find out the things that make a deed valid. If you have any further questions about this topic, leave them in the comments below. As always, thank you so much for watching, and be well. I'll see you in the next video.